Before we begin, we have an important note regarding continuing education credit. If you are an EMS provider and wish to earn continuing education credit for this program, you must view this program through Prodigy. You can set up a free account and watch this video for credit without charge at prodigyems.com. No credit can be earned by watching this video on YouTube or other platform. Electronic handouts for this session are available at the link you see here. Please note that use of these materials is subject to the PWW licensing agreement. Please take a minute to review this agreement. Thank you.
Hello everyone, and thank you for joining us for this very important webinar and town hall meeting on the Elijah McClain case, EMS legal review of the Elijah McClain case. This is probably the largest webinar attendance we've ever had, close to 3,000 people. So we're going to get right to it. We have a lot of material to cover. We're going to spend the next 90 minutes with you, so you're going to have plenty of time for us to answer your questions as well. My name's Steve Worth, partner at PWW, and joining me today as a presenter will be my esteemed colleague and friend, Doug Wolfberg. You'll be hearing from Doug in just a few moments. Going to quickly go through some of the introductory slides here. First of all, no video or audio recording is permitted. There will be a video audio recording available after the webinar, so you'll get information on that. And of course, this is an educational and general information webinar. We're not giving legal advice, so as lawyers, we have to give that disclaimer as well. This webinar is brought to you by PWW. We're now going into our 24th year of providing EMS law exclusively for our clients throughout the nation and all U.S. territories, and also our new consulting firm, our next generation national EMS and mobile healthcare consulting firm, PWW Advisory Group. And all of us at those two entities have a lot of experience, clinical experience in the field as EMS practitioners, as well as leadership experience in our industry. We also been getting inundated, would be a good word to use, requests for specific training for your organization related to the issues associated with this case. So we have several types of seminars and opportunities available for you. So please, if you're interested, let us know. We also have the CADS course, the nation's only EMS documentation certification program, developed by PWW and offered through our sister company, the National Academy of Ambulance Compliance. So for more information on having us present a seminar virtually or in person on these issues and other issues, or for the CADS course or any other course, info@pwwemslaw.com, or reach out to any of us individually as well. So I want to also recognize our sponsor for today. Very gracious of them to sponsor the program here at the last minute as we put it together quickly. That's TraumaSoft. We want to thank our good friends at TraumaSoft for sponsoring today's virtual town hall. TraumaSoft is a longtime sponsor of PWW conferences and events, and they're great supporters of EMS education like this program. They offer a complete EMS software solution which covers all the essentials for managing your assets and revenue, as well as your people and operational processes. It's a fully integrated program that includes CAD, billing, EPCR, scheduling, fleet management, reporting and analytics, all in one system. TraumaSoft is sponsoring its second technology and user conference, Evolve 24, coming up in February 5th, 6th, and 7th at the Margarita Resort in Orlando, where PWW will be presenting along with other EMS industry leaders as well. For information on the conference and how TraumaSoft can help your organization streamline your operations and efficiency, please visit them at the website indicated there. Okay? We also thank our friends at Prodigy for accrediting the webinar today for an hour and a half of CEUs through CAPC. So let me start off by giving a quick overview of where we're headed with the program today. We want to start off a little opening perspective on the criminal liability and EMS here that we see with this case. Is it time to panic? Facts and chronology of the Elijah McClain case, an overview of the Paramedic's trial that just occurred from the prosecution standpoint and the defense standpoint as well. And then we'll talk a little bit about the verdict, give you a legal breakdown of what happened in the trial, and then we'll get into the critical lessons, the takeaways, the things you need to know and learn from this case, and also some of the important cases that are coming up on the horizon that we need to watch for and pay attention to as well. And then we're going to have, like I said, at least 30 minutes for questions, answers, and comments. And we have Matt and Scott back at headquarters there, taking a look at all the questions, and they're going to be helping us at the end of the program today. But before we start, we want to make this point in that we were not involved in this case in any way, nor did we advise or represent any of the parties. Our comments and views are our own, based on our review of the documents, the testimony, the facts of the case as they were reported. So we don't have an inside line on the case. And to start it off, a lot of talk about this case, a lot of concern. Is this going to have a chilling effect on EMS? Oh my goodness, criminal liability EMS. Is it time to panic? Oh my goodness. We say no, it's a panic. It's time to learn. While this case may break new ground and may even blur the lines a little bit between negligence and criminal conduct, there is a silver lining in this dark cloud. And that silver lining can be a call to action for all of us, a call to action for each of us as well, from leadership to frontline practitioners, to learn from it and commit to refocusing our efforts on being patient advocates. That's the message here today. To always do what is in the best interest of the people who need our help, and at all times to keep the patient's best interest, not just in our hearts, but also in our actions. So that's our perspective on the case. Now, criminal liability, yes, that's new here in the sense of negligence becoming criminal liability. But folks, it's extremely rare. This is a very rare case. There's only been a couple, this one and another one right now in the pipeline. But basically, the only kinds of criminal cases we've seen in the past are people who have assaulted patients physically, have stolen their property out of their homes, that sort of thing. And those are rare as well. The overwhelming majority of EMS practitioners will work their entire career without being a defendant in a criminal case or a civil lawsuit. So it's important to put it in that perspective. And yes, it's a whole new world out there, but a lot of the things associated with this case, these are things in the control of every EMS practitioner. How you assess a patient, how you care for a patient, how you interact with others, including police, what you say and what you do, how you advocate for your patient, and how you will look and sound on a body cam video. These are things all within our respective individual control. Yes, it's a whole new world of transparency and accountability now with cameras everywhere, but if we at least do our job to the fullest and show a sincere, compassionate effort to help the patient, we can't go wrong, regardless of the difficulty of the situation. And this certainly was a difficult situation. At the very least, we want to make sure that people reviewing our actions later, they can sit back and say, hey, they did the best they could for the patient. That's really what we want to say about that. Facts and chronology of the case. The facts here are important, as we need to know them so we can better understand how we got to this point in the first place and what led to the needless death of young Elijah McClain. And the facts and the trial testimony of this case are also important to review because that does form that call for action, as I mentioned, to implement any needed changes to prevent a tragedy like this one from happening in our own community. So that's really the goal here. So to quickly review the facts, on a summer evening in Aurora, Colorado, young Elijah McClain, 23-year-old black man, was walking home from a convenience store. He just picked up a few items. A very respectful person. He even gave a bow to the cashier because he was like that. He was a very gentle person from all reports. He was wearing a ski mask because he had asthma and the evening air and cold air bothered him and affected his breathing. Someone said he was waving his arms, and someone called 911 because they said, oh, he looked sketchy, okay? So police officers responded, and despite the fact that there was no probable cause to stop him, they did. They concluded that he was suspicious, and literally within seconds, they had him down a physical contact with Mr. McClain. They told him to stop. He didn't hear him at first because he had earbuds in. Physical confrontation ensued as police acted to take control of him, and to the point of applying a carotid hold, after which Mr. McClain vomited, and then EMS was summoned to the scene. Throughout this process, he was speaking in terms of saying, hey, I'm just trying to get home, please leave me alone, and so forth. Response from the fire EMS unit, we had a 4-person ALS engine crew from Aurora Fire Rescue arrived, including 2 paramedics, Lieutenant Paramedic Peter Kuchuniak and firefighter paramedic Jeremy Cooper. They arrived on scene to find Mr. McClain restrained and in handcuffs. And after less than 2 minutes on the scene, the medics concluded that Elijah was suffering from excited delirium and decided to administer 500 milligrams of ketamine according to their protocol. Video shows that Mr. McClain was physically restrained and not actively struggling at the time the ketamine was administered. And unfortunately, they overestimated his body weight. The proper ketamine dose should have been about 325 milligrams. They estimated his weight to be about 190 pounds when in fact he weighed about 143 pounds. So he got significantly more ketamine than would have been indicated. After 2 minutes after the ketamine administration, he was placed on the ambulance stretcher, basically unconscious, limp, with visible vomit around his face. It was determined once they got him into the ambulance that he was in cardiac arrest. They initiated resuscitative measures, IV intubation and so forth. Return of spontaneous circulation was achieved, but unfortunately 3 days later, on August 27, 2019, Elijah McClain was declared brain dead and was deceased. Now, the initial autopsy report a couple months later found that the cause of death was undetermined. They did say, the medical examiner did say there was intense physical exertion and narrow left coronary artery that may have been contributing factors here. But at the end of the day, the manner of death was described as undetermined. And initially, the Adams County District Attorney Dave Young concluded an investigation and decided no criminal charges against anybody, any of the law enforcement officers or fire department personnel were even warranted. And then, of course, we know a few months later, in March of 2020, the George Floyd incident occurred, and Mr. Floyd died at the hands of police officers. That case, as we know, sparked a national outcry. And in many cases, the in-custody deaths across the country were re-examined, including this one. And ultimately, there was pressure by others to say, hey, medical examiner better look at this autopsy again. And ultimately, now the autopsy report was changed by the medical examiner in July of 2021, stating that now, instead of undetermined, the cause of death was complication of ketamine administration following forcible restraint. So now we're pointing the finger directly at ketamine and the restraint, but yet the manner of death was still listed as undetermined. Well, we have the trifecta here of legal action that could happen to anybody here in a situation like this. Started off the state attorney general, took over the case and paneled a grand jury. And on September 1st, 2021, the state grand jury indicted the 2 paramedics and 3 police officers with 11 accounts of crimes, including manslaughter, criminally negligent homicide, assault with a deadly weapon, assault by unlawful administration of a drug. And of course, we had suspensions of the licenses of the 2 paramedics from Aurora Fire Rescue. And there was a major, huge civil lawsuit filed by the family against the city and all the parties involved, including the medical director, by the way. And ultimately, that case settled very quickly for $15 million to Elijah McClain's parents to settle this case. It was the largest settlement that we saw in the Colorado history. So law enforcement trials occurred just a few months ago. 3 police officers were tried in October and November of 2023 prior to the paramedics trial in December. 2 of the officers were acquitted. 1 officer was convicted of criminally negligent homicide and third-degree assault. And that officer, Officer Rodema, was actually sentenced just about a week ago, less than a week ago, and he was sentenced to 14 months in jail, okay, with also probation, and sentencing was mainly for the third-degree assault charge, and also given probation for the criminally negligent homicide charge as well, but he will have work release and will be in a county prison. Now, I'm going to hand it over to Doug, and Doug's going to go through the aspects of the trial that are very, very important for us to consider. Doug?
Thanks, Steve. So now we're going to really do what I guess we would call the case study portion of this. And that is that we're going to go through the paramedic trial that occurred in December, because there's certainly been lots of questions about that. And I would note that when Steve was talking about the law enforcement trials, those cases were tried by the same judge. So the judge that sentenced Officer Rodema on Friday is the same judge who heard this case and is the same judge who will sentence the two paramedics. So whether that sentence is predictive of what we'll see coming up remains to be seen. So we're going to start by taking a look at the prosecution's case here, folks. Now remember, when a jury returns a verdict, they don't tell you what factors went into their decision. They just say, here's the verdict. But what we're going to do is highlight what the key portions of the prosecution's case were and the key portions of what the defense case were. So let's start with the prosecution's case. I'm going to frame it with a quote from the lead prosecutor who said this in his closing argument. These defendants treated Elijah McClain like he was a problem, not like he was their patient. And that really was the primary line of argument that the state made in prosecuting this case. Their argument centered on a failure to properly assess Mr. McClain, and that they really just, arrived on scene, saw him in handcuffs, saw a struggle with law enforcement, and pigeonholed Mr. McClain as a non-compliant young man fighting with police, according to the arguments in court. The prosecution argued that the medics failed to bring appropriate equipment to Mr. McClain's side so that they could properly assess him, a cardiac monitor, airway kit, etc., and alleged or argued in court that equipment was left on the ALS engine, which was parked about a block away from the scene due to all the police cars and activity in the area. Now, the prosecution's argument was that failure to properly assess led to the inaccurate determination of excited delirium. And we're going to come back to the use of excited delirium as a diagnosis here in a few minutes. But therefore, because they improperly determined that this was excited delirium, that they should not have been in the excited delirium protocol, and that ketamine therefore should not have been administered. And because it was wrongfully administered, the prosecution alleged that was unlawful administration of a drug. Further, because the ketamine protocol used weight-based dosing, remember, the prosecution was arguing you shouldn't have been in this protocol at all, but if you were, you did it wrong, because the prosecution alleged that because the protocol used weight-based dosing, that they inaccurately estimated Mr. McClain's weight, and they pointed out in court how there were no audible discussions on the body cam videos between the medics or with law enforcement, or even asking Mr. McClain himself about what the estimated weight of the patient was. That summed up in this quote by one of the other prosecutors in closing argument, which was, without a proper assessment, giving a drug is like hitting the gas when you can't see out of your windshield. So that was one of the themes in the closing arguments in this case. Now, as I said a minute ago, because the allegation of the prosecution was that this was not excited delirium, that was an incorrect determination by the medics, that the correct dose of ketamine should have been 0, right? And therefore, administering any ketamine was unlawful. But if they did, since they did administer ketamine, the dose was incorrect. And you heard Steve talk about how it was 500 milligrams instead of what should have been 325 milligrams. Now, this was a point of some controversy in the case. You heard Steve go through the chronology where, quite unusually, there were 2 different autopsy reports, 2 different medical examiner reports. And the medical examiner testified in trial that after reviewing additional evidence, including body cam footage, that ketamine was a cause of Mr. McClain's death. He testified in court, that the medical examiner, that he was persuaded by the way Mr. McClain changed. His condition appeared to change so rapidly on those body cam videos following the administration of the ketamine. In fact, the pathologist testified that, quote, within 2 minutes of getting that shot, it looked like he was in severe respiratory distress, which is why medical examiners sort of zeroed in on ketamine. We're going to come back and talk about ketamine specifically a little bit later. Now, very importantly, when the prosecution's case finished, the defense attorneys always make a motion for what's called a directed verdict, which is, Judge, we don't think the prosecution proved its case. You have to acquit our client. That motion usually never works. It didn't work here. But one of the other motions that the defense attorneys asked the judge to rule on was that the prosecution failed to prove that ketamine was a deadly weapon, because one of the charges against the medics was assault with the deadly weapon, i.e. ketamine. Very interestingly, the judge ruled that the prosecution failed to establish that ketamine was a deadly weapon for purposes of the law. That came down to the intent with which the drug was administered.
And the judge ruled that there was no evidence that there was intent to give the ketamine for that improper purpose to harm Mr. McClain. So that was a very significant legal ruling that happened in the middle of the trial. Now let's take a quick look at the defense case. The defense sort of said this is a systemic problem and it's unfair to pin those system problems on two individual paramedics. There were law enforcement, the policing issues in 2019. There were paramedicine practice and protocol issues. The protocol wasn't perfect. It needed updated, but they had to follow it. So that was really one of the defense arguments. They also said that looking at these protocols, there's lots of subjective words, right? Non-compliant, agitated, out of control, danger to self or others. And that these words pose challenges to paramedics who are attempting to follow in what many cases are vague protocols. The defense attorney argued this, that paramedics are required to go in and make a very rapid judgment to decide these subjective words and decide immediately if they apply. The paramedics also argued that they had incomplete or in some cases inaccurate information about Mr. McClain. They testified in court that they didn't hear police tell them that they had placed Mr. McClain in a carotid hold prior to their arrival. Now, I will note that the video does clearly show, and you can hear audibly, police officers giving that information to the paramedics, but they testified that in the chaos of the scene that they did not hear that information. They didn't know that Mr. McClain, testified that they didn't know that Mr. McClain had said he can't breathe or that he had lost consciousness prior to their arrival. They did say that they were told by the police, and there is evidence of this on the body cam footage, that Mr. McClain was exhibiting superhuman strength, that he did a push-up with 3 officers on his back, which is also seen as a sign of excited delirium. They argue that even though they didn't touch Mr. McClain, they didn't use a cardiac monitor or end-tidal CO2 or get really down face-to-face with Mr. McClain, they argued that they did a visual assessment. And they testified that they could do that visual assessment by looking and seeing visually that he was breathing fast, he was moving and therefore had circulation, that he was sweating, and that they didn't need equipment to make those determinations. So that was part of the argument about the assessment. There was a very sort of dramatic courtroom moment when one of the expert witnesses was on the stand in the trial and he was asked, "Can you see the prosecutor at his table?" "Yes." "Can you tell if he's breathing?" "Yes, I can." Right? So, pointing out that you can gather information from a visual assessment, but the prosecution argued that that was inadequate. The defense attorney said this in the closing argument. I suppose this may generate some interest and debate in our circles in EMS. "There did not appear to be a need to get that equipment with all the wires on it. What's that going to do? Wrap wires around his neck or somebody else's? Equipment would bring more risk and less calm to the scene," argued one of the defense attorneys in closing statements. Now, ketamine was largely on trial here too, because the administration of ketamine in the second medical examiner's report was found to be one of the causes of death, along with forcible restraint. So let's talk a little bit about ketamine. In the trial, the paramedics produced evidence that they were trained that ketamine had a broad safety profile, that they were trained that even with a mistake in dosing, it's still safe in the pre-hospital setting, that Mr. McClain's blood concentration of ketamine was therapeutic and not toxic, and this quote, that there is no evidence that anyone ever died from a single dose of 500 milligrams of ketamine. Now, there was also considerable back and forth on the facts that Steve talked to you about with the fact that there was a change in the medical examiner's report. The defense argued that the autopsy showed that Mr. McClain had a narrowed left anterior descending artery, LAD, and that there was evidence because of vomiting and aspiration that there was acidosis contributing to Mr. McClain's condition following aspiration. And the defense did produce evidence from the medical examiner himself that he was pressured in many ways about his first autopsy report being inconclusive, and that it was unusual to be asked by a different law enforcement agency, in this case the state attorney general's office, to revisit a case. He said this, "I did receive death threats. We had to step up our security at home. It's unusual for a separate agency to ask me to relook at a case." Now, another very interesting argument that we're going to get to in a minute with the lessons learned is arguments that the paramedics council made that they were really not able to promptly access Mr. McClain, that law enforcement had control of the scene, that they had control of the individual, and that they didn't release the handcuffs the first time that the medics asked them to do that. There is evidence of that on the body cam videos as well. They testified that at the time of this incident in 2019, there was no policy on when a person becomes a patient if they're in police custody, but that the custom had always been that the patient is not ours until the police remove the handcuffs. So that whole issue was very interesting in the trial. We'll talk a little bit more about that. And the defense attorney took that argument and incorporated it into his closing, which he said this: what is the medic supposed to do at that point? Say, hey, back off my patient, right? So they were sort of arguing that the police were in control. All right, let's take a quick look at the verdict. This was, I think, what a lot of observers, a lot of lawyers like us, looked at, and we thought it was a pretty inconsistent verdict. And I'll tell you why here in a second. Paramedic Kachuniak was found guilty of criminally negligent homicide and second-degree assault by unlawful administration of a drug. Paramedic Cooper was found guilty of criminally negligent homicide, but not guilty of a second-degree assault. Interestingly, it was Paramedic Cooper who actually administered the ketamine. So one could argue that this verdict is a bit inconsistent, but nevertheless, that's what the jury decided. I will note that the jury in the police case was somewhat inconsistent as well, because they acquitted the officer who placed Mr. McClain in a chokehold, but convicted the officer, one of the officers on scene, who did not apply the carotid hold. So there's really some inconsistent verdicts in this case. Whether that becomes an appeal issue remains to be seen. Now, because of the assault charge, which is actually more serious in terms of a sentence than the criminally negligent homicide charge, Paramedic Kachuniak was taken into immediate custody. Paramedic Cooper was left to be free pending his sentencing. Sentencing is scheduled for March 1st. The ranges are 1 to 3 years for criminally negligent homicide, 5 to 16 years for second-degree assault. We mentioned that Officer Rodima got 14 months, but that was third-degree assault. This medic was convicted. One of the medics was convicted of second-degree assault. So it remains to be seen how the judge will sentence based on that difference. And the day after the verdicts, both paramedics were terminated by AFR. Their employment was terminated. Okay, let's now sort of transition from the case study into what we think are the most important or critical lessons. I'll start this off and then Steve will jump in. The first one, I think, that's the biggest takeaway here is how EMS interacts with law enforcement. Interaction with law enforcement must be improved. Period, hard stop, end of sentence. We need better policies, better protocols. We need scenario-based training. We also think it's important not to take at face value what you're told by law enforcement or really any observer or bystander when you get to a scene. Now, folks, any inputs, any information that comes to you as an EMS caregiver should be considered, right? It all gets factored in. What a witness says, a family member, a bystander, the patient, right? Sometimes patients give us incorrect histories purposefully, right? Or law enforcement, right? Everybody may have an agenda that they're trying to advance through the reports that they give. So you have to look at that independently and you have to look at that critically. Talk, communicate, ask for others' opinions, right? All of this in the name of optimizing patient care. It's also important, I think this is one of those things that seems like it's obvious, but we're going to say it, and that is that the duty of care that EMS providers have is to the patient, right? Not to assist law enforcement, but it's to be patient care advocates for that patient. Any actions, any interventions, any treatments, medications, restraint, anything we do has to be in furtherance of patient care, not in the assistance of law enforcement. And one comment that a lot of folks made after this case was that everybody needs to stay in their lanes, right? Now, folks, please understand, this is not anti-law enforcement or how we interact with law enforcement. The overwhelming majority of the time, the relationship between law enforcement and EMS is good. It's beneficial. It helps the patient. It helps the public. It's good for everybody involved. It helps keep providers safe. It helps keep patients safe. Helps keep the public safe. But that is not always the case, and it was not the case here, right? So our job isn't to help law enforcement. Our job is to advocate for the patient. And anytime we use physical or chemical restraint, right, it can only be used when it is in furtherance of patient care, when it follows an appropriate patient assessment, and Steve will talk about that in a second, and when it is indicated under an applicable clinical protocol or directed by online medical control. You know, the next, we think, very important lesson here, take a quick sip here, is a duty, and there's lots of emerging duties of care, right? You know, legal duties of care aren't static, they evolve. And one new duty that's really evolving is the duty of EMS practitioners to access the patient, right? And what we mean by that is law enforcement scenes can be hectic and chaotic, right? Now, Mr. McClain wasn't a bad person doing bad things, but sometimes when we arrive on a law enforcement scene, there may well be a bad person who's done bad things, right? We don't judge. Steve will talk about that a little bit later. But law enforcement officers control a scene, but we control the patient, right? We have a duty to access a patient in custody of law enforcement. PICKLE, that is the acronym that we've developed for that term. As soon as EMS concludes, even just visually, right? Because some people say, well, we don't have a patient relationship until we actually contact the patient. If I can visually see and gather information that that human being is in need of health care, we treat them as a patient, and we have a duty to access them as soon as that becomes apparent to us. And anytime, folks, that law enforcement or anyone else for that matter is impeding, delaying, preventing patient access, EMS practitioners have a duty to speak up. And folks, if the police say, we don't care, we're throwing them in the cruiser and taking them in, it would really be nice if the body cam videos in a future case showed the medics or EMTs speaking up and saying, that person needs our help. We really want to take care of them. Can you please release the cuffs or open the cruiser door so we can help this person, right? The duty to speak up, to be able to access the patient. We can't take medical control or medical directives from law enforcement officers or any treatment instructions. If a cop says give ketamine, it may well be that the patient needs ketamine or benzos or whatever else, right? But that can only be determined after a complete, appropriate patient assessment, okay, and pursuant to an applicable protocol. Let me talk about protocols for a second, because that's really the second major lesson here. First, let's talk about medical director engagement, all right? Your medical director needs to be actively engaged in developing, monitoring, and updating your EMS clinical protocols. They have to be key participants in educating and training your folks, quality review of incidents, helping you identify circumstances in which online medical control may be beneficial to patient care. And folks, we talked about the fact that ketamine is largely on trial, right? We're seeing politicians passing laws. We're seeing a lot of political debate about ketamine. I personally do not like political involvement in standards of care and how we treat patients. Ketamine does have a safety profile. It is demonstrated to be very safe. However, we can't all sit back based on a study from however many years ago and say, oh, this is safe, don't worry about it. If we want to use ketamine in our systems, we need to keep proving that it is safe. If your system uses ketamine, consider 100% chart reviews on the instances where it's used. Have ongoing clinical oversight and ongoing public transparency and accountability about its use, and that you are monitoring it through QA, and that you are reviewing cases and updating your policies and your protocols when necessary. Revisit. It's a good time to look at any protocols that deal with interacting with law enforcement, dealing with patients who are in custody, any protocols dealing with the administration of ketamine or benzos, or paralytics or anything else, right? Protocols on agitated and combative patients, excited delirium. And, you know, you might also, it's a sad state of affairs in our country when you say you might also want to have legal review of your protocols, but that's becoming increasingly important, particularly with protocols that deal with high risk, controversial, or high exposure situations. Quickly, let's talk about excited delirium. This diagnosis is falling out of favor quickly. Some states have legislatively outlawed the use of the diagnosis. Several professional societies are abandoning its use. And the reason behind that is that there was thought to be a significant correlation with the use of that term as justification for excessive force or improper medication of people in custody. And that disproportionately affected minorities, according to lots of the data. Now, let me talk for a second here before I turn it over to Steve about this argument we hear a lot in EMS, how protocols are just guidelines, right? Yeah, we have laws, we have regulations, but protocols are flexible, right? Well, we all tell ourselves that within the EMS circles, right? But any of you who watch this trial, and the videos are on YouTube, you can go back and watch some of this trial, the prosecution used those protocols as very rigid standards of care on what the paramedics should have done and failed to do in this case, right? Whether they should have even been in the excited delirium protocol, and then whether they properly followed it once they were. Those were key issues. Now, folks, last thing I'll talk about here before I turn it over to Steve is really one of the more important, I think, legal lessons, and that is that this case really, and a few others we'll talk about it before we're done, really marks a very important legal shift here, right? And I can't tell you how many times colleagues of mine that I've spoken with in one-on-one and in presentations I've done that, well, wait a sec, how can healthcare providers or EMS practitioners even get criminally charged? They didn't intend to hurt or kill the patient, right? Well, folks, the answer is, look at the laws under which these defendants were charged. Reckless manslaughter, criminally negligent homicide, right? Those are negligent terms, right? Recklessness and negligence. That means the prosecution does not have to prove intent to harm. These are not intent-based crimes. These are acts that are done with a significant degree of recklessness or carelessness. Prosecution doesn't have to prove intent. Now, if some of you are saying that sounds a lot like medical malpractice, where civil cases are brought when we make mistakes, yeah, it is, right? So these concepts of malpractice and negligence can form the basis of criminal charges that are, for example, reckless manslaughter and criminally negligent homicide. To put it another way, yeah, malpractice can become manslaughter. Okay, let me turn it back to Steve, who's going to pick up the ball here with patient assessments.
Okay, thanks, Doug. The third big takeaway here, folks, is getting back to the fundamentals, patient assessments. We got to do a thorough assessment. We can't just go along with the show when we see a chaotic scene and just, jump to the conclusions and give ketamine based on directional law enforcement and so forth. We got to have a thorough patient assessment, or at least attempt to provide a thorough patient assessment. That's the key. So we really got to go back to the basics. And one of the most devastating issues that we saw in this case, in the trial itself, was the prosecution literally debunking the claim that a visual assessment was sufficient, okay? And the expert that was on for the defense said, hey, they checked the pulse, and they went through it, and they didn't really check a pulse, okay? Nobody really got down to the patient's head and really assessed the situation, and the decision to give ketamine was made very, very quickly. So there was no indication of that in the video or in the evidence that came during the trial. So absolutely essential. We got to think about what we're doing. Any EMS treatments or interventions that we provide are always going to be suspect if they're not based on a foundational patient assessment. We got to have objective and documented clinical findings that support each of those interventions. Why we're giving this drug, what were the signs and symptoms of the patient that led us to conclude that he needed this medication. And that requires bringing the equipment to the side of the patient. You got to have the tools of the trade there. One of the criticisms here was the equipment was left in the engine. Well, that was a little ways down the road, but what's wrong with carrying it to the scene and having off to the side in case you need it? Okay, that's important. We don't want to be sitting there with no equipment when the patient goes bad. So absolutely critical. We all got to think about too today, what's going on is cameras are everywhere. We need to be conducting our assessment and even almost verbalizing what we're doing as we do it. Okay, I'm assessing the head, neck, and spine here. I'm assessing the skin. It's cool and clammy and it's, pink, whatever it might be. But saying that out loud can also help reinforce what we're doing, and for the video cameras as well as in our own mind to make sure we're going down the checklist of the head-to-toe assessment and so forth. Sort of what we call performative patient care, because it is kind of like a performance, okay? And we want to do the best possible performance we can for that patient for their own good, as well as for outside observers who are now more frequently going to be Monday morning quarterbacking these situations because of the advent of video cameras and so forth. So very important that we get back to the basics. Remember, we advocate for the patient. Everything we should be doing should be in the best interest of the patient, especially with that patient care and that assessment. Another takeaway here is the issue of social justice and health equity. It did not come out as a big issue in this case, but yes, the bottom line is we all have prejudices, okay? Thoughts that run through our minds based on our upbringing, our background, our experience, our exposures. We go into bad neighborhoods, so to speak, and look how many cars are in the driveway. Here we go again. When you keep getting the same kinds of patients and the same kinds of calls, certainly we could also have biases that affect what we might think is going to be happening here in this situation. We got to sort of control those things and recognize that we can't let those biases and prejudices affect how we treat the patient. And this is all based on documentation of, research, folks. It's not just us saying this. There's been a number of studies over the past 10 years in healthcare. It's a problem across healthcare, racial bias in pain assessment and treatment recommendations. We all see that in a number of situations. Patients who are elderly females with mild shortness of breath, we sometimes may dismiss that, but they could be having a heart attack because we know they often don't have the classic chest pain and so forth. Somebody short of breath that could be having a pulmonary embolism, but if we think or conclude that they're breathing rapidly because they're out drinking and they're hyperventilating, now we jump to conclusions. So it's very important to address this role of implicit bias within healthcare delivery, and we're starting to see more and more efforts in EMS to do just that, and that's very, very important. Now, as I said, there's no direct evidence that race played a role in this case. It did not come into the trial, but the reality is that in many of these high-profile cases, police and EMS providers are white, the patient victims are black, so it's something we have to be concerned about, and we need to be part of that national conversation and discussion to understand the role of these biases playing in a larger issues of social justice and health equity, because everybody needs to be getting access to the same level of care, regardless of the neighborhood you're in, your economic status, the color of your skin, your religion, whatever the case may be. And the data clearly shows that there are inequities in healthcare, including in EMS, among many underserved and minority populations. And we have to make an effort to identify those disparities and make sure we're looking at that in the QA function. Let's just not look at, okay, did they give the right drug and so forth, and did they do the right things here on the list? But one of those things should be, did we treat this patient as we did other patients? And look at the health equity issues in that as well. And certainly we got some great opportunities with the data that's available to us through our EPCR programs, data surveillance. These are the things we could also use to act to address any of these disparities that might be found, okay? That's in the direct patient care. Well, what can we do in the workplace? Well, we can work to strive to increase diversity, to increase equity and inclusion. We all know that predominantly the fire service has been predominantly white Anglo-Saxon males. We see that in EMS. Women are now into the industry very well, but we do show many times that the employees of EMS and fire departments and police officers, police departments, do not always represent the makeup of the community or are representative of the populations that are being served. So we need to make that a priority, because we work better when we have a diverse workforce. We're less apt to make errors. We're more likely to have a healthy and happy workplace. The studies also show that as well. So that has to be a priority for EMS agencies to well and faithfully care for the populations that we serve in our particular communities. So that's essential. Implicit and confirmation bias. Implicit bias are those attitudes, stereotypes, beliefs that can affect how we treat others, as we mentioned. There's a whole slew of different kinds of categorizations that we can use: race, ability, gender, economic status, the neighborhood they're in, etc. But implicit biases generally run contrary to our stated beliefs, okay, as opposed to explicit bias, where we're saying racially inflamed terms or whatever. But we say we believe in equity and we truly believe it, but sometimes we unintentionally behave in ways that are biased and discriminatory. Hey, that's just human nature, folks. We all are like that. We all have some of these biases that affect, because we are what we were when. We are a product of our upbringing, the things we've been exposed to. And you know, if patients are yelling and screaming at you, spitting at you, kicking you, telling you get the hell out of here, and being rude and obnoxious and difficult, you know what? We might expect that the next patient's going to be like that as well. And we got to be careful that we don't prejudge the next call based on limited information that we might get from dispatch or whatever, based on the neighborhood we're being sent to. Let's look at everything objectively. Let's get these implicit biases under control. So we need to first off recognize that implicit and confirmation bias can impact EMS practitioner actions and care, or lack thereof. And just part of the human condition, be aware of them, work to neutralize their efforts. And we got to do some education on this subject. We've been doing a lot of seminars lately on dealing with biases in EMS care and treatment and how we can deal with them. So it's something we really do have to pay attention to. And it's all about awareness. And you know, part of the problem too is, look, it's tough out there for everybody. We're overworked, we're underpaid, we're dealing with difficult situations. People call for EMS who don't need EMS, and we're under pressure. We're running one call after another. And that's when these implicit biases most often manifest themselves in bad behavior. When we're under pressure, when we're multitasking, when we're in a big fat hurry, okay? Can any of those situations apply to EMS? Absolutely. And that's where leadership needs to take a role. We need to make sure we're doing our best as leaders to reduce the cognitive overload that occurs from going on one call right after another, and now we're backed up with 6 patient care. What a day, okay? So these are the things we have to pay attention to across the board, from top to bottom up within the organization. A similar kind of bias as implicit bias, compared to implicit bias, is confirmation bias. And that's just not seeking out objective facts, interpreting information to support your existing belief, only remembering the details that uphold your belief, and ignoring information that challenges your belief. Hey, we've probably all worked with a partner who said, when you went into that elderly lady who was having mild shortness of breath, or a young person who was slurring their speech, oh, they're on alcohol, they're on drugs. You know, well, what about, could we check for signs of stroke? No, this is not a stroke. You know, that type of thing. We work with strong personalities, and sometimes our strong personality reaches a conclusion too quickly, and then we tune out any other objective information that may be contrary to that initial conclusion. That's what confirmation bias is all about, and that's what we need to work on as well. Implicit bias, confirmation bias. Well, here's another big takeaway from the case, folks. As you know, video and body-worn cameras, or BWCs, are everywhere. We have to act as if the camera is on us at all times, because there's all different cameras. We got these cameras everywhere. We got bystanders. We got family members in the house taking video. So if we don't have them on our person in EMS, the police have them. So we want to make sure we're looking good on the camera. Overhead traffic cams, business and home surveillance, everywhere. Ring systems, whatever it might be. And when it really comes down to it, how we act is really up to us as individuals, okay? And we want that video to look positive. You know, even when it's a difficult situation, it's always up to us as the individual EMS practitioner to choose how we will look on that video. Are we calm and courteous and professional? Are we compassionate? Are we doing things that show that we're focused on the interests of the patient? Did we bring the tools of the trade by the patient's side? Did we thoroughly assess the patient and treat the patient with care and not indifference? Okay. One of the things Judge Warner said in this case, it's disturbing in the sentencing hearing of the police officer, was, I am shocked by the indifference that was seen here when Mr. McClain was handcuffed and in custody. And that's not good. We don't want people to see us that way. Stand up to law enforcement if necessary. Do it in a positive way. Work ahead of time. As Doug mentioned, we got to make sure we work out our protocols and procedures ahead of time and we practice them. We do mega codes all the time. Why don't we do mock scenarios with mental health issues and people in custody and work together with law enforcement to develop a pre-plan, so to speak, to make sure that when everybody's at the scene together, everyone knows what they're supposed to do and we have our responsibilities planned out ahead of time. And if we don't intervene, if we see somebody inappropriately applying pressure on a patient's chest or whatever it might be, and we don't do anything about that, shame on us, because that means we're just nothing more than a bystander. That normalizes improper conduct. When you allow it, it will continue. And the person engaged in that conduct will then be affirmed. They'll feel it's okay. And others will see, oh, that's acceptable. So if one person is not polite to patients and rude and obnoxious, and others may start to act that way as well, unless we do something about it. We can't be bystanders to improper conduct when we see a patient who needs us. That's got to be priority one. And complacency is taking hold. We've seen more cases involving complacency and not doing the fundamentals, as we may have seen in this case here today that we're talking about. But you don't want complacency. That's bad enough. You don't want it to lead to complicity in a crime. And that's what could happen if you sit back and are a bystander to potentially criminal activity. Okay. And yes, we got to think about our practitioners in the field, the people on the street, right at the front line. Their safety, wellness, and accountability is important. And we're not saying just charge into the scene and start doing an assessment. No, we got to make sure that we have appropriate scene safety procedures in place. We got to do that in conjunction with law enforcement so they know, that we need to be kept safe, but they also know that we have to get access to the patient, as Doug mentioned. So we got to have training that's focused on prevention of workplace injuries and assaults against providers. It's a big concern. Healthcare providers and EMS practitioners in particular are assaulted far more often than other healthcare workers. In fact, OSHA is now looking at healthcare as an issue in terms of issuing guidance and directives on workplace safety programs and anti-violence programs. So we got to put a high priority on provider mental health. We got to help people. The old days of saying, oh, you come to work well rested and don't even nod off. Well, maybe some places are having rooms where people can take a nap and get a break. We got to have a system where people can call out appropriately to make sure that we don't have people treating patients who are not in the right frame of mind to do that. So we really got to focus on providing resources for our EMS practitioners and our folks on the front line. And when it comes down to duty, what's the legal duty here? Well, as Doug mentioned, we have a duty to access the patient. We show up, we got to do something. We can't just walk away, okay? Look how that looks in a visual, when from the public looks and say, what are they doing? Okay, they're not doing anything. We have a legal duty, a moral duty, and a professional duty to act for the benefit of the patient. And that's a duty to take proper actions to prevent harm to the patient and the public. I think that's the best definition of our duty, preventing harm to the patient and the public. And everything we do should be focused on that simple duty. And what does the public expect? They expect us to show up looking good, well-trained, acting like we want to be there, moving with a purpose, bringing the tools of the trade to the side of the patient, getting down on the patient's level and intervening. Look, somebody in custody who's, flailing around and difficult to deal with. Yeah, sometimes we're not able to get everything done, but we make an effort. At least when somebody's looking at that body camera later, they're going to at least say, hey, they made an effort to do what was right for the patient. That's what we want to have happen. Accountability, we think about that, it's not only what we do for which we are accountable, it's also what we do not do for which we are also accountable, okay? Not bringing the equipment to the side, not giving the patient oxygen when they needed it, not bringing the stretcher and loading them up on the stretcher, instead having them walk to the ambulance. And it's not a bus, it's an ambulance, okay? It's a sophisticated healthcare delivery vehicle. We also have a duty to accept patients on their terms and on their time, regardless of whether they put themselves in that position or not. We're not there to judge them. Whether it's 3 in the afternoon and they're in a pool of vomit outside the mini mart, or it's 3 in the afternoon on the hill at the mansion and they're sitting in their nice chair by the pool, okay? It doesn't matter. We accept patients when they call, on their terms, regardless of how they got into that situation, and on their time, whether it's 3 in the morning or 3 in the afternoon. And lastly, this is a great plug from Joel Osteen that was provided to us by our friend Joseph Zalkin from North Carolina. We should never forget this, and if we follow this adage, we can't go wrong. Your job is not to judge. Your job is not to figure out if someone deserves something. Your job is to lift the fallen, to restore the broken, and to heal the hurting. And if we remember that quote, we can't go wrong. And lastly, from my standpoint, if we just sit back a second on every call and just reset ourselves, okay? Take a deep breath in, let it out slowly, and ask yourself as you move into that situation, it takes 5 or 6 seconds, am I doing what a reasonable EMT or paramedic should be doing in this same situation? If the answer is yes, go forward. If the answer is no, you might be an outlier. You might be hanging out there. You might be subject to potential claims down the road. So that's an important little practical point. And with that, I'm going to turn it over to Doug, who's going to wrap it up here before we get into the questions and answers on important cases on the horizon. Doug?
Okay, thanks, Steve. So yeah, real quickly, we just want to put on your radar a couple of other criminal cases in EMS. One is in Springfield, Illinois, the Earl Moore Jr. case. This involves just about a year ago, December of 22, 35-year-old patient who was experiencing alcohol withdrawal and hallucinations, went into cardiac arrest after he had been placed in a prone position by 2 EMTs, was forcibly restrained with cot straps in that position. Cause of death was determined to be compressional and positional asphyxia due to that EMS restraint. Those providers, folks, were charged with first-degree murder. So about as serious as it gets. That case is not yet scheduled for trial, but it is on the docket. Those charges are still pending. The Tyree Nichols case did not involve charges against EMS practitioners, but did involve charges against 4 police officers after Mr. Nichols was severely beaten by Memphis police officers. 4 officers were charged. However, 2 EMS practitioners had licenses suspended. 3 were terminated from their employment. And the state found that they had failed to promptly access Mr. Nichols and provide prompt care. A third one that's not quite on as many radar screens is actually here in Pennsylvania, where PWW is located. And that's a case of manslaughter, involuntary manslaughter against a 911 dispatcher who refused to send an ambulance when a patient's daughter called to request medical help. And the dispatcher asked, does she consent to going to the hospital? And, put her on the phone, and she couldn't speak. And the dispatcher, refused to send an ambulance based on not getting assurances of consent to transport, which is bizarre, but that dispatcher was charged with involuntary manslaughter. That case is still pending. All right, to wrap up and get into questions here, folks, the Elijah McClain case has changed EMS, the world of EMS, or has it, right? Steve talked about how we each have a choice, how we're going to come across when we interact with police, when we're on body cam footage, when we deal with patients. We love this quote that was posted in response to one of our posts on social media. Being a compassionate provider never led to an arrest or a courtroom, which is a good way to sort of think about it. To wrap up here, folks, we want to, I think, clearly remember that deviations from protocols and standards of care not only can constitute malpractice, but can have criminal consequences. We have to recognize new expectations that are in place with criminal charges for how we interact with law enforcement. You still control your actions, your appearances. If you want more information on training from PWW, you can email us at info@pwwemslaw.com. Let's jump right into the Q&A. First one, would the liability of the providers have been different if they had followed their treatment protocols to the letter and the patient outcome had been the same? You want to take that one?
Yeah, I'll start it off, and I'm sure you can add to it as well. Would the outcome have been different? I don't know. I don't think so, because I think it wasn't just the protocols. I think it was the care that was provided. The lack of assessment was a key point in the prosecution's case. So it was more than just the protocols and not meeting maybe all the particular elements, because they did meet a number of those elements. So it really came down, I think, to just the whole context of how they conducted themselves at the scene, at least as it was presented in the trial. And again, we're not here to judge them. We're just here to base our thoughts on what we saw and what we observed. So that's my thought about it. Doug?
No, I agree with everything you said, so I don't need to belabor the point. It was well stated. A question that's come in that's, we've been doing so much factual analysis of this case. Somebody has asked, what's our opinion about whether these paramedics should have been criminally charged in the first place? We really haven't weighed in too much with opinions, but since asked, I'll share mine. These are personal. It doesn't necessarily reflect Steve's or anybody else's. I do not think that criminal charges should have been filed in this case. There was a civil malpractice case. Steve talked about that earlier. I think departures from clinical standards of care should be civil matters. I don't want to deny justice for the McClain family. I do see that the chain of events put into place here was precipitated by police officers on the scene. I think there may have been mistakes made in clinical care, but I think prosecutors really have to think carefully about the chilling effect of sending the message they send when they charge EMS practitioners criminally for deviations from medical standards of care. That is strictly my opinion, folks. This case is a tragedy. The McClain family does deserve justice, and there are changes that need to be made. I just don't think that justice should come in the form of criminal charges against paramedics. My opinion. Yeah. Steve, do you want to weigh in?
Yeah, I couldn't agree with you more wholeheartedly, Doug. Absolutely. We don't think this should have been a criminal case. And the problem with it is it makes these paramedics victims of a systemic problem. They're the victims of the system, so to speak, okay? And as we talk around the country to people, just about everybody we've spoken to has said, this kind of thing could have happened here. We tend to short shrift patients at times, maybe we're overworked, whatever it might be, okay? But no, it should not be criminalized in our view. And frankly, I don't think it changes behavior. It doesn't. It victimizes then the people involved in the case. And granted, if they did something really bad to the patient, they should pay for that. No question. But certainly we need to look at the bigger system issues. And hopefully when we look at the numbers, very rare that we're going to see a case like this. And if we do our job, we're compassionate to patients, we shouldn't have to worry so much about these kinds of cases, hopefully.
Yeah, I agree with that. And I think it's also important to say that, from everything we know, this department involved, AFR, has been conscientious, has been learning lessons from this case, has been doing a good job in updating policies, procedures, protocols. Right. This could happen in just about any department or in almost any EMS agency in the country. But I think it is important to remember, if you're a medic or an EMT having a bad day, right, the consequences for that can be pretty significant, as we saw in this case.
Doug, let me just throw one other point in here. We also got to remember we're looking at this from 2018. We're talking 2019. So a lot of changes have been made, and we know for a fact this department has made major changes, as have many departments around the country as a result of these cases. So we're looking at this 3 or 4 years later.
Yeah, and hindsight's always 2020. All right, Steve, I'll give this one to you. Was there any interdepartmental review of the medic's actions or the protocol before the criminal case?
Well, we're sure there were interdepartmental reviews. The particulars of that, we're not privy, we don't know, but there's a lot of great public documents available. We know there was extensive review of this case. If you look at the consent decree materials, and if you type in Aurora, City of Aurora consent decree, it is chock full of all sorts of materials that talk about the internal investigations, the things that have been done since then. So yes, so there have been a lot of positive things done in that regard.
Yeah, and there's also the city of Aurora has not shied away from accountability in this case. They settled the civil matter. They have a web page. It's on your reference slides that really collects all the reports and materials. There was a report by the county DA when he decided not to prosecute, which is very interesting reading. And there are some other accountability reviews. So take a look at the materials on the references. I would say there's some stuff there. I'll take this next one. Is it common for a state attorney general to take over a case after the local prosecutor has decided not to file charges? No, that is not common. And honestly, that was something that the defense had every right to point out in the trial, that the medical examiner's report was revised after intervention from the state attorney general's office. That is not a typical way that criminal cases are filed. Even though this case was heard in the county court in Colorado, the state attorney general, deputy AGs, were the prosecutors in the case. So this was not a local DA decision to prosecute. That is unusual. It is unusual for a state attorney general to intercede, which does bring a political, character or flavor to this case, certainly, which is why we laid out the chronology that this case was brought after the George Floyd case, where many state AGs were reviewing cases of in custody deaths. So, Steve, anything?
Yeah, and I think, I think it's you can't just say it was a political prosecution, as some have said. There was much more to it, as we explained here. And the fact is, folks, the world has changed in terms of accountability, visibility, transparency. And those are the things we got to be thinking about as we go forward, and always act to the best interest of the patient.
Well said, as usual, partner. All right, next question. How can EMS providers protect themselves when encountering a patient where law enforcement is actively interfering with their care? Go ahead, Steve.
Okay. Well, they got the badges and the guns, so you got to be a little careful there, as we say. But you hopefully you've worked this out ahead of time, but you need to try to pull somebody aside and say, look, we need to get in there, because if we don't get in there, everybody can go down here, okay? There's whatever it takes to say, look, this person is having difficulty breathing. Maybe recite to the officers, hey, he's saying he can't breathe. We need to get in there and check to make sure his airway's open. Those kinds of things. Use what you see and repeat it back to the officers and tell them what you need to do. I mean, that's, a practical stand. Is that always going to work? No, not always. That's why it's important to work these things out ahead of time. Doug?
Yeah, well said. And I would add that, you may not always win those battles. You should.
Right.
Police should relinquish custody of a person who needs health care. However, I think, and folks, don't everybody lose their crap over this statement, but what I'm going to say is that, and you kind of alluded to this earlier, Steve, EMS is in large part performative, right? We are performing, whether we like it or not. We need to be high quality, compassionate, clinically competent caregivers. But remember, we are on stage. We are on camera. And if law enforcement is delaying or impeding or obstructing, at least make sure that those damn body cam videos are going to show us advocating for the patient and asking for access to the patient and telling the police why we believe that person needs care. And if the police still refuse, that's a bad situation for the patient, but we would expect not to see this kind of legal liability bouncing back on the medics or the EMTs or the EMS practitioners when they can be seen advocating in that way. Okay, next question.
Partner.
Thank you, sir. Do EMS personnel have any legal protections for defying orders from law enforcement that are not in the patient's best interest? I'll start with this one. No, really, they do not. There's no statutes that say EMS providers who refuse improper instructions from law enforcement shall have legal protection. There isn't such a law. What I would say, however, it would be the absence of prosecution that would be your protection, right? If a cop says, give this SOB ketamine or whatever, right? Or a benzo or a paralytic or you name it, or if it's BLS, do this and restrain him. Don't give him oxygen. He doesn't deserve oxygen, right? If we just blindly follow those instructions, we're inviting liability. If we say, We'll assess and then do what's in the best interest of the patient. Doesn't matter if he's a good person or a bad person, how he got into custody, what he did to, get into that situation. Our job is, as Steve said, not to judge. If body cam videos and other evidence show us making that stand, I think that's your protection.
Well
Steve?
said. Well said. Can't add to that one. Excellent.
All right, next question. Steve, this is for you. Did the paramedics need to contact medical command before administering ketamine? Was medical command ever contacted?
Yeah, I mean, most protocols don't necessarily require calling medical control. We've gotten away from the Mother May I system, and I don't believe, Doug, you correct me, I don't believe they contacted medical command in this situation. I didn't see any evidence of that in terms of online medical control. I know in the aftermath of this case, some medical directors have added that as a requirement, but most have not. Many systems have gone to different medications as well as an alternative, but I'm not aware of medical control being contacted here. But if it was in the protocol that said you should, well, then there should be some attempt to do that. Doug?
Yeah, agreed. Nothing to add to that one. I'll take the next question. Who drew up the ketamine? So interestingly, the officer in charge on the ALS engine, which was Lieutenant, later Captain Kachuniak, went after some delay. There was a transport ambulance. Remember, this was an ALS engine. The transport ambulance got to the scene after some delay, and the lieutenant paramedic asked the crew of the transporting ambulance to draw up the ketamine, asked for 500 milligrams of ketamine specifically, because the ALS engine did not have ketamine in stock at that time. So the ketamine was actually given to the crew by the Aurora crew by the transporting ambulance service.
Yeah, they did actually go through the R's. They checked the right dose, right drug, and all of that. So that was done in the handoff of the medication, as I recollect.
They certainly testified that they did that. That's right.
Yes.
Testified to in trial. I think that part of the interaction was outside of the view of any of the body cam videos, though, if I'm not mistaken. What is the criteria for the crime of criminally negligent homicide? If you, under Colorado law, the prosecution has to show, and Steve, I'm just taking this one because I happen to have the elements in front of me.
Yes.
That the defendant caused the death of Elijah McClain through criminal negligence, which equals a gross deviation from the standard of care that a reasonable person would exercise, resulting in the failure to perceive a substantial and unjustifiable risk that a result would occur or that a circumstance existed. So very legally wordy, but it's a gross deviation from standards of care, right? So there is a difference between regular malpractice, which is a deviation from a standard of care, and criminal negligence, which is a gross or substantial deviation from a standard of care. And folks, if you're saying, well, somebody give me the criteria for what's regular and what's gross negligence, I'll be appreciative, right? There really aren't, right? If you do this, it's simple negligence. If you do that, it's gross negligence. It's these kinds of legal definitions that prosecutors have to decide, judges have to interpret, and then ultimately juries have to apply. So that is one of the difficult gray areas of this and other criminally negligent cases. And
Doug,
again,
don't you find it interesting, the definition on the criminal side, gross deviation, it's almost like the definition on the civil side of gross negligence, isn't it?
It is, and in fact, we were watching the trial when the judge gave the jury instruction, when the judge was talking with both parties, prosecution and defense. It's a mind-numbing part of a trial where the parties work out what the jury instructions are going to be. And then the parties agree, judge gives those instructions. They actually used concepts from civil law, like recklessness and negligence, in the criminal jury instructions. So if you're thinking, folks, that there is a blurred line between negligence and crime, you're not the only ones.
Well, it's an interesting point, too, because, when you look at negligence, we have a lot of immunity statutes that protect you from ordinary negligence, which is just a mistake, but you could only be found liable in a civil case if it's gross negligence. So now, in some cases, you might see prosecutors look and say, well, we can do the criminal side, might even be easier to some extent, at least, when you look at these definitions.
Yeah. Okay, next one has my name on it, for Doug. Do you think the paramedics in this case are examples of paramedics being, quote, too comfortable, or was there another contributing factor, lack of sleep, lack of training, issues with law enforcement on scene? Yeah, so there was no evidence that there was sleep deprivation, no evidence that there was lack of training. There was evidence of training introduced. I think the biggest gap in training and policy was that there was no written policy on how EMS interacts with law enforcement at the time of this. I think that was one of the contributing factors. Too comfortable? I don't know about that either. I think the testimony revealed this was the first time that the paramedic had given ketamine, actually, after AFR received their ketamine waiver from the state. So I don't think any of those were factors in this case. I do think that what motivated the prosecution to file these charges was what they saw as a cursory, improper assessment, a rush to judgment of excited delirium, and administration of ketamine without fully taking into consideration the condition of the patient at the time of the injection. I think those are the main factors. That's my opinion. Anything you want to add, Steve?
Yeah, just I talked to a couple of paramedics in the area there, and they said basically that it is one of the busier areas of Aurora, one of the busiest engine companies. So yeah, you could have compassion fatigue, and that's the concern about the cognitive overload that we talked about, and people running calls one after another could have an impact on how they act. Okay, was that the case here? We don't know if they ran 20 calls or 2 calls that day.
Yeah, that's well said. And again, we don't have any insight on these individual defendants, right? And on March 1st, when that hearing, the sentencing hearing takes place, the public will no doubt see another side of those defendants. There will be sentencing statements made from colleagues of theirs. They may testify or speak to the judge about in their own defense, try to get the judge to mitigate the sentence. We're going to see the good things that they've done. We're going to hear another side of the story, because there always is another side of the story. So it's very hard to, sort of say what's in a person's mind and what's in their heart. But I think the sentencing hearing will be very interesting to see that other side and see how the judge responds to it. Next question, Steve, I'll toss this one to you. What type of precedent does this set for EMS? Will more EMS agencies be subject to criminal or civil liability moving forward?
Yeah, that's a very good question. Part of the answer is we don't know for sure. We still believe that these kinds of cases are going to be very rare, okay? We're not going to see many of them. So I don't think it really is a precedent that we're going to see an onslaught of criminal charges against paramedics and EMTs in the field. I really don't. I think the key is, especially if we take the lessons from this case and work to improve and do better, it's going to be less likely, perhaps, actually, that we'll see more of these cases. So that's just my quick off the top of the head. Doug?
I agree with that. Yeah, I don't think we should despair. I don't think we should lose sight of that this is a good, noble profession. And I just really want to emphasize what Steve said earlier, that every single EMS provider has the ability to control how they act, right? And if we're worried about, is the system going to come after us? Well, guess what? That feels like something out of our control, but everything else is in our control, right? How we act, how we interact with people, how we treat patients, how we interact with law enforcement, how we're going to come across on those body cam videos on the 6 o'clock news, right? So I really want to emphasize that we can exercise our own control about a lot of these factors. Okay, next one I'll take. How did these paramedics explain the need for ketamine in this situation? Quite simply, the need for ketamine was explained by their determination that Elijah McClain was experiencing excited delirium. And they argued in court that they may have been medically incorrect in that conclusion, but they were reasonable to conclude it at the time, right? You can't apply 20/20 hindsight, that they said there were factors that suggested excited delirium, That may have turned out to not be the case, but you have to look at what they were confronted with at that time. So the justification for ketamine was the conclusion of excited delirium, even if that conclusion turned out to be incorrect. Steve, this one's for you. If a 4-person ALS crew was dispatched to the scene, why were only 2 paramedics of that crew charged?
We don't know that answer, really. The prosecutor just opted to charge the 2 who were most involved in the patient care. That's, the reasonable explanation for it. So, some people didn't get charged. I mean, some asked about the medical director, others. There were people from the private ambulance company. They weren't charged. So it's really a matter of discretion by the prosecutor looking at the elements of the law and what does he or she think he or she can prove is really what it comes down to. Doug?
Yeah, I would add to that the other 2 crew members were not paramedics on the engine, right, and really did not have hands-on or direct involvement in the care of Mr. McClain or the decision to use ketamine or any of those. One of the other engine crew members was an EMT basic who did take the stand, and I'll let folks interpret this how they will, but the answers to most of the questions he was asked was, I don't recall. So I think, the industry, took some allegations of that, thin blue line, thin red line, protecting each other after that testimony. It was very interesting. Next question. Oh, sorry, go ahead.
No, I'm just going to say, as you're thinking out loud here, you've said, Doug, in a number of cases, ketamine was on trial here, and it's not the ketamine, it's what we do with it is really what it comes down to. And someone asked about studies and reviews that were done. There was extensive review. I recall looking at one report where they looked at all the ketamine cases during 2019 to 2020. And in those cases, there were 22 of those cases actually where ketamine was given in this kind of situation. They found that there was a lack of proper monitoring of the patient in many of those cases. So that's something, to think about. It really comes down to the assessment, the decision to do it based on assessment, and then monitoring the patient. And talking to medics and medical directors as well, I was talking to Jim Augustine yesterday, Dr. Augustine from Lee County, and it's really pretty easy to do capnography. It's basically a nasal cannula, okay? And to measure that patient's end tidal CO2, it lets you know if they're breathing or not, and it's going to give you a much quicker indication of deterioration of the patient's condition than pulse oximetry will, which could take up to 5 minutes maybe. So just a couple of quick thoughts.
Yeah. Okay, next question. I'll just take this one real quickly. Was the medical director of the service held responsible? No, there were no criminal charges filed against the medical director in this case. The medical director was named in the civil case, which did settle. So no criminal charges, nor would I have seen a basis for any criminal charges against the medical director, but he was included in the civil case, as many other parties were, and as we said earlier, that case settled. Steve, did the defense use the pre-existing hypoxia due to the police restraint as a contributing factor to the patient's overall outcome?
As I recollect, they did, but, again, it didn't seem to come out as clearly as it maybe could have in this case, the carotid holds and so forth, because Mr. McClain's condition clearly deteriorated to unconsciousness basically after there were 2 carotid holds applied. So I don't know to what extent that they really used that. And unfortunately, in these cases, you had law enforcement, when they were on trial, they were pointing the finger at, EMS and the ketamine, okay? And of course, on the other hand, EMS is going to say, no, it was more the wheels of disaster were set in motion by law enforcement with the improper stop and the improper detention and so forth. Yeah, so I don't know. What do you think, Doug?
Well said, and they did say that exactly, that the wheels of this tragedy were put in motion by the police. But there was finger pointing, and I just want to say this again. Everything I said about the relationship between police and EMS earlier still stands. It's a good relationship by and large. It benefits us. It benefits the public. It benefits patients. That said, when you look at the body cam video, we're gonna give him some ketamine as soon as the ambulance gets here. Perfect, dude. Perfect, right? There's this bromance going on. yeah, we'll do this. Well, guess what? When these cops were on trial, they threw the paramedics squarely under the damn bus. Okay, and just remember that. All right, that when you're faced in that situation where we want to cooperate and help law enforcement, that's great. But remember, our duty is to the patient. And folks, those police officer defendants did not hesitate to say squarely that it was the ketamine the paramedics administered in this case that killed Elijah McClain. But for that ketamine, he wouldn't have died. It wasn't us, Your Honor, or ladies and gentlemen of the jury. Just keep that in mind.
Excellent. Well said with passion. But I want to add just what was said by the defense attorney in the police officer's case. It was an interesting quote. He said, ladies and gentlemen, the police officers, they're kind of in charge. Those are the words he used, kind of in charge. And they passed the baton to EMS, and it was EMS and that ketamine that killed Elijah McClain. Very telling, as Doug said, how they pointed the finger, but it's also very telling when the defense attorney says they're kind of in charge, which basically says, we got something to work on here. Who is really in charge? Okay. It wasn't really well defined, and when it comes to patient care, we need to make that delineation. Our friend AJ Heitman had a good suggestion. He said, put in your procedure with law enforcement that when EMS arrives and when they say something like our patient, out loud, that's a cue to law enforcement that, hey, let us in there, let them in there, that kind of thing. So lots of opportunities to talk and to discuss solutions and ways to better improve that relationship so we don't have these kinds of cases again.
Okay, let me grab this one quick. We have about 3 minutes. How did the medic that did not give the meds get convicted of assault? And the second part of the question is, how does medication administration without consent, because that was part of the charge here, apply to patients without capacity? Which is, I think, something a lot of people scratch their heads about. First part of that, I don't know. I think the jury's verdict was inconsistent about why it was the medic who asked for the ketamine and not the one who administered the ketamine who was convicted of the second-degree assault. Whether that proves to be an appeal issue, we'll see. Medication administration without consent, that is the name of the charge here. But keep in mind that that charge has a lot to do with things like date rape drugs and that kind of stuff. That was the charging statute here. But that statute, we've looked at the language, it does also say without medical justification. So if you had a patient who lacked capacity and the appropriate protocol was to administer a medication, even if the patient couldn't give consent, the law of implied consent would be appropriate medical administration of that drug. At least that's how I see it. So
yeah, and there's that specific exception, as you said, for proper medical care. But the other aspect of implied consent, too, to point out is that implied consent is based on the notion that if a reasonable patient who's now unconscious, if they would have been awake and would have given that consent, then consent is implied. So there has to be a degree of reasonableness. So if Elijah could have, decided to consent to that drug, would he have? And I think that's an aspect of implied consent that a reasonable person would have given the consent that we sometimes forget.
That's true. I think, you can hear the body cam video, Elijah McClain saying before he lost consciousness, things like, I'll do whatever I have to do. It was, it's very difficult to watch and listen to. Mm-hmm. Steve, I'm going to give you this question. This may be the last one. Do you believe EMS providers should wear body cams? Would that have been beneficial in this situation?
Yes. Well, body cams are front and center, folks. And, you think, oh boy, if they didn't have body cameras, this wouldn't happen. No, we don't think so. They're everywhere. It's a sign of the times. It's what society is expecting. Accountability. We've worked with a number of EMS agencies in developing an effective body cam program where they use these things to quality improvement, to improve documentation, and there's a procedure for them. We believe that they're in the best interest of EMS to have them. That's a personal, individual agency has to think about the pros and cons, but we see more good in having them than not having them. And I can recall cases when we had the drive cams only, and many times people were concerned about that. But more times than not, it got EMS out of trouble because People make false accusations against us, okay? Imagine that, folks, okay? And this can help save your butt, so to speak. So positive things in my view. Doug?
Nothing to add. That was very well said. So, folks, that does bring us to the end of the webinar today. We want to, again, thank our friends at TraumaSoft for sponsoring the event. We want to thank the folks at Prodigy for their continuing education sponsorship and hosting this on their platform, CAPC for the continuing education approval, and most importantly, all of you for attending and asking your outstanding questions. I wish we had another 2 hours to get to all the questions. Maybe we'll do another event where people can just ask questions. But in any event, we do very much appreciate your participation. On behalf of my partner, Steve Worth, and everyone here at PWW who has worked hard behind the scenes to make this event happen, we'd like to thank you all for participating today. Have a good day. Be safe. Thank you all for your service.